Hello everyone, my name is Valerie Stanek. I am an attorney in private practice. I'm also a financial planner. We're going to talk today about what getting your affairs in order means and what to share with trusted family and friends. You'll leave this presentation feeling empowered and ready to get organized. Our presentation today is going to talk about putting your affairs in order and what exactly that means. What affairs are we talking about? And how do we put them in order? We're going to talk more specifically about your legal documents. We're going to talk about your wishes regarding medical care if you should become incapacitated. We're going to talk also about communicating with your family regarding your burial wishes and your funeral arrangements. We're also going to go over assets and debts and how to organize information about those things for your family in the event that you should pass away. We're going to also go over some miscellaneous documents that should be on hand, or at least copies of which should be on hand. More importantly, in this day and age, we really need to address your online presence, such as social media, your online access to banking accounts and investments, etc. And then we're going to put that all together and talk about exactly how you might think about organizing that in the event that something should happen to you. Putting your affairs in order is a phrase that we often hear when we talk about the end of our lives. But what exactly does that mean? Well, in typical lawyer fashion, my answer to that is going to be, it depends. Putting your affairs in order can mean a very different thing from one person to the next. It depends on your circumstances. For example, are you a high net worth individual? Are you an average income earning individual? How many family members do you have? And what type of particular circumstances do they have? For example, do you have heirs that have issues with their marriages? Do you have heirs that might have chronic health conditions or a disability? It also depends on the nature of your assets. Putting your affairs in order is going to be more complicated, for example, if you happen to own a business. It also depends on what your values are and what your goals might be. Is it important to you to minimize your taxes? Are you concerned about a possible estate tax if you were to pass away? Are you concerned about providing for the costs and expenses associated with nursing care or an assisted living facility? Is it important to you to protect your assets from the creditors of your heirs? Do you have a ne'er-do-well son-in-law who's always racking up debts and you're concerned that your daughter's inheritance might be squandered? Are you concerned about reducing the expenses and the delays associated with probate? Are you familiar with what those expenses and delays might look like? Is it important to you to simplify transfers of assets to your heirs? Is it important for you that things run smoothly and seamlessly for them? Putting your affairs in order is very important to most people, but a lot of people haven't given a lot of thought to what that really means and what it needs to look like for you. Putting your affairs in order begins with your legal documents. I'm assuming that you have wills, trusts, healthcare proxies, and powers of attorney in place. If you don't, this might be a good time to consider those documents. They're important for just about everyone. One of the most important components of all of these legal documents is the transfer of your authority to act on your behalf in the event that you can't act for yourself. For example, the executor under a will and the trustee under a trust are empowered with making decisions about the distribution of assets after you've passed away. The agent under your healthcare proxy makes decisions for you in the event that you are incapacitated and can't make decisions for yourself. The agent under a power of attorney makes decisions about your assets while you're living, but while you might be absent or incapacitated. It's important to decide who are these people that you're going to entrust with this decision making and this authority. Another important decision is, To what extent are you going to turn over the authority? How much authority are you going to keep by limiting their authority when you write these legal documents? Another important consideration is, how are your accounts owned? Do you own all of your accounts outright? If you were to pass away, how would they get transferred? Would they have to go through probate? What would that cost? How much time does that take? If you were to own them in joint name with someone else, what does that mean? And what would happen to a joint account like that if you needed to go into a nursing home? All of those considerations need to be addressed in order for you to really have put your affairs in order. Another important consideration is the ownership of real estate. Again, do you own it outright? What does that mean if you were to pass away? What does that mean in regards to taxes and probate? And if you were to own it jointly with someone, for example, you put your children's name on it, what are the pros and cons of doing that? Is there another way to pass real estate on to your children? And what happens in the event of a stay in a nursing home? Ownership of business, like the ownership of real estate, needs to be considered. How is the business owned? Is there an arrangement as to how the business would be disposed of if you were to become incapacitated or pass away? Another important consideration is beneficiaries. The beneficiaries on your life insurance policies, your annuities, your various accounts are very, very important. But you also have beneficiaries named under your will. How do those interact with each other? If I have a beneficiary named under my will, but it isn't the same one that's named on my IRA, for example, what would happen? Who would actually get that money? Are these documents and account beneficiary designations in conflict with each other? Those things should be looked at, and they should be set up in such a way that your assets flow seamlessly exactly where you want them to if you should pass away. So let's assume that you've taken care of all of those considerations in the earlier slides. Now what are we going to do with all this information, and how are we going to communicate it to our family members and loved ones if something should happen to us? Well, first of all, what we want to do is secure your legal documents such as wills and trusts. These documents are not too difficult to forge or to alter. Therefore, we don't really recommend that you keep them at home. Most people leave the original of their will with their attorney, who keeps it in a vault or a safe in their office. They keep copies of the will at home with instructions and contact information for the attorney in the event that they should become incapacitated or die. Some people file their will in surrogate's court, and certainly they continue to do so. This is the traditional way of handling the will. However, most people today, as I said, leave their original with the attorney. By contrast, you're going to want to provide easy access to a healthcare proxy. You want to keep an original yourself. You want your attorney to have an original. You want all the agents under the healthcare proxy to have an original. You want your doctor and the hospital that you're most likely to go to have an electronic copy on file. And you should keep one on the refrigerator, because EMTs coming into your home, if you call an ambulance, are trained to look on the refrigerator for such things as healthcare proxies and lists of medication. As for powers of attorney, you want to be cautious with those documents. They're a very powerful legal authority to act on your behalf in regards to your financial matters. You want an original copy to be with your lawyer. You want to keep an original copy yourself. You probably want to provide a copy to your primary agent under the power of attorney. The primary agent should be someone that you trust, and therefore you should be comfortable with them having an original of that document. You want to keep other copies where you can find them. Make sure that someone can find an original of the power of attorney in case it's needed. In other words, At the very least, someone should know how to contact your attorney, who will have an original of these documents on file. In regard to your medical care, you want to be very open and clear with the agents under your healthcare proxy. You want to have a verbal conversation with them in addition to naming them the agent. And you definitely want to let them know that they're the agent under your healthcare proxy. You don't want to create a healthcare proxy and put it in a drawer and the agent doesn't even know that they're named as the agent under your healthcare proxy. You want them to know how you feel, to know what's important to you, and to accept the responsibility for making decisions for you. You also want other loved ones to understand why you've named the person that you've named to be your healthcare agent, and you want them to understand generally what your wishes are so that they're not shocked and surprised at your bedside if you should become very ill. You may want to put it in writing in a personal letter and tuck it away with your other documents, just so that everyone is on the same page in the event that you become sick. Bear in mind that a healthcare proxy is a very different document from a MOLST. A healthcare proxy gives your agent the authority to act on your behalf, but it doesn't give very detailed instructions, generally speaking, as to what type of care you would want. A MOLST, on the other hand, is a legal New York State document that outlines exactly what you would want to have happen in regards to feeding tubes, in regards to DNRs, in regards to hydration, in regards to antibiotics. All of those things are spelled out. A MOLST form is usually put together when you become older and you have a hospitalization, and it usually happens in conjunction with medical personnel in the hospital. Healthcare proxies are a more general document, and it's really a passing on of authority rather than specific information about the details of your care. Given that healthcare proxies don't provide detailed information, it's not a bad idea to have a MOLST form on hand and also put the MOLST form on your refrigerator. You may also want to leave instructions in regards to the disposition of your remains and your funeral arrangements. The disposition of your remains can be specified in your will, in your healthcare proxy, or both. What we mean by this is you may want to leave instructions regarding whether you want to be cremated or buried, whether you want to donate your remains or donate organs, and the disposition of ashes should you choose cremation. You may also want to talk about your funeral arrangements. You can leave specific requests in your will or your healthcare proxy again. You can also prepay or pre-plan a funeral and leave instructions as to where the funeral home is and what type of funeral you have pre-planned. When you're organizing, you definitely want to have a list of your assets and debts. You want to list your bank accounts, your investments, stocks, bonds. I put stocks in bold here for a reason, to remind myself to tell you that stocks can sometimes be problematic, and bonds as well, because sometimes they're sitting around in a certificate. They're not in an account. Your house isn't receiving regular statements. And even if you do, you might receive a statement once a year rather than on a monthly basis. So you definitely want to have listed any stock certificates and where they can be found, or any stock accounts, stock clearinghouses, and contact information for that financial institution. You also want to have information about your retirement accounts, not just IRAs and 401ks, but also pensions and annuities. Again, those are the types of assets that don't necessarily receive statements in the mail very frequently. You want to have access to information about your life insurance, health insurance, and long-term care insurance. You want to have cards, policies, and certificates on hand. I mentioned certificates here because certain types of group insurance don't come with full policies. They only have a one-page certificate that shows that you have this type of coverage. Very often, life insurance proceeds, for example, go unclaimed because they were through your former employer. You had a certificate, but it was nowhere to be found, and no one bothered to claim that life insurance after your death. Make sure you have copies of deeds to any real estate that you own. You want to have business establishment documents. You want titles to vehicles. And you also want to have information in regards to any credit card, loans, mortgage statements, vehicle loans, any other debts that you might have. Other information that should be readily available are such miscellaneous documents as marriage certificates, birth certificates, social security cards, driver's licenses, your passport. Military discharge paperwork is particularly important under certain circumstances because if you are or your spouse was in the military in active duty during a time of war, you may be entitled to benefits, pension, VA benefits, that you're not even aware of. And this is particularly true if you need some type of nursing care or some type of assisted living facility. You also want to have any certificates of naturalization if you were a naturalized citizen as opposed to born a citizen of the United States. If you're the type of person who spends some time online, you may also want to be sure that your family has information regarding your online presence. For example, do you want your social media accounts to live on after you pass away, or do you want them to be deleted? If you want them to be deleted, someone needs to have the username and password in order to get on that platform and delete the account. Do you have automatic payments and subscriptions set up online? If so, someone needs to get onto those accounts and cancel those automatic payments. Likewise, online access to your credit cards, to bank accounts and investments, all such online access to various types of accounts should be canceled in the event of your death. In order to do that, again, usernames and passwords and lists of what types of accounts you have access to online are very important. So how is it that we're going to communicate to your family members or your loved ones where all of this information is in the event that you pass away? I recommend that everyone keep a binder or folder or box including the following information. Contact information for your lawyer. Your lawyer presumably is going to have the original of some of these legal documents and a list of other financial information that you have given him or her, and it would be very helpful for your family to have contact information for your lawyer in order to get that information. You want to also list the documents that the lawyer has in their possession so that the family member or loved one who is following up knows exactly what they can expect from the lawyer. You're also going to want to leave information regarding the whereabouts of any of the legal documents that you may have in your own possession. For example, you may not want a power of attorney to be left in the binder or folder because that's not very secure. You may want to have it in a safe deposit box. Well, you may want to have information in regards to the safe deposit box in this binder, folder, or box that you're putting together. You're going to want to have a copy of your healthcare proxy and a copy of your MOLST in this location. You're also going to want to have a note in regards to your funeral wishes and burial wishes, as well as a personal note in regards to your medical care. In this box or binder or folder, you're also going to want to have a list of all assets with the financial institution, the account number, and the contact information for the financial institution and for any advisor that you may have. I put financial institution in bold because while it's a good idea to have contact information for your financial advisor, the financial advisor may retire. So you definitely want to also have information for the financial institution You want a copy of all of your miscellaneous documents, such as driver's licenses, marriage certificates, etc., as listed previously. You're going to want to have information on your online accounts and where to find your usernames and passwords. I recommend that you keep that in a safe or in a safety deposit box. You can also keep it in a safe place online, such as Keeper, for example, an app. But then, of course, someone needs to know how to access the safe, the safety deposit box, or the online vault, if you will. Last but not least, it's very important that you update this just in case information regularly. So the information in your binder or box or folder that is there just in case you pass away or just in case you become incapacitated needs to be up to date. If you have a will that you have canceled and now you've written a new will, you definitely want to note that in this just in case box. If you have an account that has been moved from one place to another, you definitely want to update the information so that the old account is not listed and the new account is on the list. Those types of updates need to be done, I would say, on an annual basis at the very least. You want to also leave a record of how to find this just-in-case binder or this just-in-case box. You want to leave that information with your lawyer who has your legal documents. You could leave it with a spouse. You could leave it in your safety deposit box. You could leave it in your safe. But again, someone needs to know where this information is, and preferably that someone would be the types of people that you're trusting to be your executor in your will, the people that you're trusting to be your agent under your power of attorney, the people that you're trusting to be your healthcare agent. Thank you very much for listening today. Again, my name is Valerie Stanek. I'm an attorney. Please feel free to call me or send me an email if you have questions. Also, feel free to contact me to set up a free initial consultation. Once we are able to meet face-to-face, I'm happy to sit down with you and discuss any questions or concerns that you might have. Give me a call. My number and my email address are listed here. Take good care.